We're back on the air. My name is Jeffrey Davis, and remind all our listeners we want to thank our host, Pat Clendenen of Davis Malm, and his partners at the law firm of Davis Malm. And our next guest, someone I know you know very well, Richard Sampson of the firm of Davis Malm and DeAugustine.
So, Rich, why is intellectual property such an important issue for businesses, generally speaking? Why do they rely on you so actively on a day-to-day basis?
Well, the short answer is it's such an important asset for these companies, and whether it's a Fortune 500 that has a portfolio of intellectual property, or whether it's a startup that is just getting going. And it's an interesting issue because the IP person gets called in first, and you have oftentimes before there's much if any money, because it's really important to lock down the IP at the beginning, because it's very much protect it or lose it. And so it's fascinating. So you spend a lot of time with the inventors and entrepreneurs right at the outset. The nice thing about trademarks and copyrights is that you have rights as soon as you begin to use these things. And so there's nothing that's going to be lost if you sleep on your rights. But the opposite is true for patents. So as soon as you disclose your patented or potentially patentable idea publicly, you have immediately lost any hope of ever protecting that invention overseas. And here in the States, you've started the 12-month clock running in which to get something on file. So it's really important to make sure that startups have non-disclosure agreements in place and are keeping things under wraps until they're ready to get something on file with the Patent Office.
Well, what's happening in the federal courts these days that the listeners should be aware of?
At the Supreme Court level, we have generalists, they're non-IP trained people. There is the appellate court that's right below, that feeds the cases to the Supreme Court, is the Federal Circuit. And the Federal Circuit, they are trained. That's the exclusive appellate jurisdiction for patent cases. And so, but what we're seeing is that there's been quite a run of the Federal Circuit being overturned by the Supreme Court in recent years. So what we're seeing is a gradual erosion of the strength of patents here in the U.S.